Greetings, my fellow freedom loving sovereign thinkers. Thank you for tuning to LO3 Podcast. My name is Craig, transmitting from the beautiful, swampy Mango, South Florida, and today's date is Wednesday, March 24th, 2021. Looks like spring break is almost over, so all the college kiddies will be going back to school. And, of course, you got a bunch of riffraff going around, know-it-alls, geniuses, all trying to be an attorney. It's nothing new under the sun, folks. That's the things I observe. I just start laughing. Yeah, I had one girl, nice-looking, attractive woman, asking for a mask for one of the vendors. She didn't want to pay. Well, sorry, honey, you're not obligated. Everyone wants a free hand on the lunch. Well, Walmart's down the road. And, of course, people still talking about what happened, the horrific events that happened in Boulder, Colorado, and, of course, in Atlanta. And it's interesting, Mike Adams from Natural News made a great point, because I watched, too. All the 10 people that were murdered in Boulder, Colorado were white. So, I'm not going to know half flag, half staff, supposedly. I don't know. I'm not making any judgment. And he does attest to the person, the assailant. It can be quote unquote MK Ultra, mind controlled. It is possible, folks. Like I said in my last episode about it could be a Manchurian candidate. Can't really, always question these things. And of course, the politicians are all running their mouths, tough for gun laws. You got the social media geniuses on Facebook, all of those sites. I own a firearm, but I do support licensing and registration. Well, sorry, young man. Sorry, Junior, you haven't really studied history of the Weimar Republic, and you hate Nazis so much. Explain how the Nazis took advantage of gun control. Okay, so study your history before running your mouths. And that's for a lot of people out there. No condemnations. I'm not going to say his name by any means, but I just do find that pretty absurd. All these, I'm a social media genius, SMG, right? Come on, get a grip. And, hey, it's just one of those things you always have to pay attention. You see all these patterns, problem, reaction, solution, the Hegelian dialect. Remember 9/11? Oh, yeah. They use that well. COVID-19, mass shootings like on a state level, the horrific event that happened at Marjorie Stoneman Douglas at Parkland. Yeah. Just give you some examples, my friends. And it's not mocking these events, okay? It's just everyone's just like wig out, live in fear. Don't get me wrong, evil is everywhere. And we have a moral obligation to defend ourselves, families, and innocent people when it's necessary. This is why I'm pro-self-defense, pro-natural law. I don't need politicians telling me how to think, live, and wipe my own rear end. You see, I'm going to have something that's considered illegal in your eyes is null and void, invalid contract, regardless if it's federal, state, or local. And of course, I did raise about what happened in Boulder. They did try to ban semi-auto weapons, but the AR-15, but the courts in Colorado says it's illegal. Okay, and even the states can make those laws, but they're still unconstitutional. All you gotta do is hear my last show, yesterday's show on Boulder, the Boulder shooting, Boulder supermarket shooting. Okay, because I laid down the facts, no exceptions. But everyone's trying to, even Ted Cruz. Oh, mentally ill is that, but who's going to constitute that? When it comes to government, you never trust them. All right, so if folks want registration and so forth, you spearhead it. You register your own damn things on your own watch. Do it on your own free will, but don't try to tell me or anyone else how to comply. That's a fact. I'm a freedom lover, sovereign thinker. I'm not in these little partisan politics. And don't get me wrong, there's some people from both sides that are good folks. I met a lot of people from both sides that are good folks, and believe it or not, we have a great dialogue. We have awesome discussions. Because it's called respect. I don't go on these little propaganda tirades, which the mainstream garbage media is very good at. They've been doing for a very long time. Always question these things, folks. And who's going to benefit the most? Corrupt politicians and organized crime. Prove me wrong if you dare. That's my rant on that. Speaking of gun control, this one here came from the Epoch Times, and it came by Jack Phillips. Came out today. It says U.S. Appeals Court rules state may restrict people from open carrying guns in public. All right, this is what Jack Phillips has to say. It says, as it reads, an appeals court on Wednesday ruled that states may restrict people from openly carrying firearms in public, upholding a Hawaii gun regulation that bans residents from openly carrying guns without a license. The Ninth U.S. Circuit Court of Appeals ruled 7-4 that restrictions on carrying guns in public except for hunting do not violate the Second Amendment rights to bear arms. The government may regulate or even prohibit in public places, including government buildings, churches, schools, and markets, the open carry of small arms capable of being concealed, whether they are carried, concealed, or openly. Judge J. Bybee, appointed by former President George W. Bush, wrote his opinion for the court's majority. Our review for more than 700 years of English and American legal history reveals a strong theme. Government has the power to regulate arms in the public square, the judge called, saying there is no right to carry arms openly in public, nor in any such within the scope of the Second Amendment. Bybee added, it remains as true today as it was centuries ago that a mere presence of such weapons present a terror to the public, and that widespread carrying handguns would strongly suggest that state and local governments have lost control of our public areas. See, you hear this? You hear this? Good grief. It reminds me when I study history of Rome, when a certain group of people couldn't have swords. All right, just think about that. Just study a little history here, folks. Judge Daramid F.O. Scallion, who dissented the decision unprecedented as its extreme. It is the core of the Second Amendment protects the ordinary law-abiding citizen's right to carry a handgun openly for the purpose of self-defense outside the home. Despite an exhaustive historical account, the majority has unearthed nothing to disturb this conclusion, wrote O'Scallion. Well, good. I like that. Another judge who dissented, Ryan D. Nelson, criticized Hawaii's county law, writing that it restricts gun ownership only to security guards and violates the Second Amendment. In 2016, the Ninth Circuit decided that Americans don't have a constitutional right to carry concealed guns in public. The National Rifle Association wrote that ruling impacts the right to carry laws in Alaska, Hawaii, Arizona, Washington, Oregon, Montana, and California. This was not an NRA case, but we are exploring all options to rectify this, the group wrote on Twitter. I can let you know how to do it. Let the people in those states should challenge these laws, even if you have to take it to the courts through jury and have the jury nullification. That's one of the things you can counter this, okay? I'm going to continue on here. Okay, the case was brought against the state of Hawaii by a man who sought a permit for open carry for self-protection, but was later denied. According to the Los Angeles Times, evidence in court showed that the county's permits were only given to security guards. The only county law has limited permits for carrying guns other than hunting for persons with an urgent need for firearms and who are involved in the protection of life or property. The case is Young versus State of Hawaii. So, let me just check this out here. Oops. One moment. I'm gonna work on this, folks. This is very, very interesting. And I should have done this before I've done the show. So, it's interesting about the case because if you study these things, on the state of Hawaii and all that. Sorry for the vibrations. Good. So I got that out of the way. Sorry for the vibrations, folks. And it is very disturbing indeed. Yeah, this is how many pages? 215. Wow. Let's go. Let's see what it has to say here. I'm going to go all the way down to conclusions. Interesting about that case, Young versus State of Hawaii. Yeah, I just okay. Interesting about this case. As it says here, I'll just hit the last couple of paragraphs. There's no preemption under Hawaii state law here, and a non-binding AG opinion does not control despite majority suggestion to the contrary. Contra Major Op at 19-22. Municipal ordinance may be preempted pursuant to HRS 46-1.5 subsection 13 if subsection 1, it covers the same subject matter embraced with a comprehensive state statutory scheme disclosing an expressed or implied intent to be exclusive and uniform throughout the state, or 2, it conflicts with the state law. Richardson versus City and County of Honolulu, which happened in 1994. There is no express preemption clause in the state statute at issue here, nor any clear intent to preempt regulations such as county. See generally HRS Statute 134. Also, Agenda Seeds, Inc. versus County of Kauai, which was in 2016. So the Hawaii Supreme Court has presumed that county exercises of police power is within delegated authority so long as the legislator not clearly intend to preempt the field of regulation. That's Employees versus Association, Government Employees Association versus Maui, 1978. The parties don't argue such preemption exists either. And because the AG opinion is legally non-binding, it cannot preempt the county regulations as state law. Okay, so they got the case of Cedar, Shakespeare's City of Los Angeles. I don't know what's like Los Angeles here, 1993. Furthermore, deferring the county interpretation of its regulations advanced in this amicus brief is not warranted under the limits inherent as administrative law doctrine. The deference is proper only when agencies' interpretation of its own regulations survives a gauntlet of conditions. The first, the regulations must be generally ambiguous. Second, the agency's interpretation must be reasonable. Third, a court must take an independent inquiry into whether the character of the context of the agency interpretation entitles it to controlling weight. Fourth, the agency's interpretation must in some way implicate its substantive expertise. Finally, an agency's reading a rule must reflect fair and considered judgment. An interpretation that is a convenient litigating position or post a hoc rationalization does not merit deference. The general rule then is not give deference to agency interpretations advanced for the first time in legal briefs. The county's interpretation does not meet any of these requirements. Thus, the county's interpretation advanced for the first time in its amicus brief is not worthy of any deference. That was Christopher versus Smith Klein Beecham Court, 2012. Independent review of how county regulations have been interpreted and applied by local officials demonstrates the county unconstitutionally enforces HRS 134-9 through its regulations. See Chapel Calvary, of course, as a state church. The county regulations were promulgated to govern the granting of the authorization for the carrying of weapons as provided by Section 134-9, Hawaii Revised Statutes, and the county regulations titled Rules and Regulations Governing the Carrying of Concealed Weapons and the Carrying of Weapons by Private Detectives and Security Guards explicitly applies HRS 134-9 only to certain occupations. Under the county regulation, that open carry is proper only when the license holder is in the actual performance of his duties within the area of his assignment. Second Amendment surely does not protect a right to bear arms only as a security guard. Young versus Hawaii, that's 9th Circuit in 2018. Reg Hambant granted, as in 2019. Thus, the county regulations are infirm under any of the standards of scrutiny. The county regulations are facially unconstitutional, and Young alleges that they have been unconstitutionally applied to deny him have a permit under HRS 134-9. The majority of failures to grapple with the county regulations in meaningful ways suggest and unwillingly to apply Second Amendment with the respect it deserves. Even if Hawaii statutes were facially constitutional, as the majority holds, Young's challenge should be remanded to address or develop the as-applied challenge. Therefore, I respectfully dissent. So, 7-4. That is interesting. So it's fine by 7-4. States may restrict. This is on a county level. But here's the thing: when you look at this, okay, it contradicts their own Bill of Rights, and this is what these numbnuts don't see it that way. And of course, a permit or a license is a document approved by competent authority. That's according, I'm just paraphrasing, that's according to Black's Law Dictionary. All right, here's what Hawaii Article 1's Hawaii Constitution, which is entitled Bill of Rights. All right, we'll hit Section 2. Rights of individuals. All persons are free in nature or equal their inherent inalienable rights. Among these rights are the enjoyment of life, liberty, and pursuit of happiness, and the acquiring and possessing of property. These rights cannot endure unless people recognize their corresponding obligations and responsibilities. So, right there, he has the right to carry without a license. Okay? We'll just hit here. Section 5. No person, which is due process and equal protection. No person shall be deprived of life, liberty, or property without due process of law, nor be denied the equal protections of the laws, nor may deny the enjoyment of the person's civil rights, or be discriminated against and excised thereof because of race, religion, sex, or ancestry. Well, live here, Section 5, that violates that. Okay, we can hit number 8, Section 8, rights of citizens. No citizen shall be disenfranchised or deprived of any rights or privileges secured to other citizens unless by the law of the land. We'll hit 17, Section 17. And Section 17 reads here, right to bear arms, a well-regulated militia to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, bam, you don't need a license. Another one. We'll hit Section 22, under construction. The enumeration of rights and privileges shall not be construed or to impair or deny others retained by the people. So his rights have been violated by, you can say, 5 sections of Hawaii's Bill of Rights. Counties can't really do anything about it. It's null and void. They can make all these things that they want, but the county has no rights, period. I don't care if you have those preemption laws. You go by your Bill of Rights. The people in that county have an oath to protect and defend both U.S. and Hawaii constitutions. Period. I suggest everyone knows that don't comply to the licenses. Everyone just start carrying. As long as you don't violate others. Be responsible. Have a higher standard. Armed society is a polite one. And if you get arrested, if you have a jury of your peers, jury notification. There's no victim. How's that a crime? Not guilty. Bingo. you'll win. It'll be a lot of headaches, don't get me wrong, but we got to stand for what's right, that including the state of Hawaii. So those little laws, the permits are null and void. Prove me wrong again if you dare. Speaking of states' rights, I'm going to do one here. It says, states just need to say no. This is by Michael Maher from 10th Amendment Center. Came out today. And it says here, I've never attended Mardi Gras, but I have experienced a private themed mega party known as Gasparilla in Tampa, and I watched a lot of people breaking the law. I witnessed hundreds of revelers drinking alcohol from open containers. I bumped into countless publicly intoxicated partiers. I even saw women exposing their breasts in exchange for 10-cent plastic beads. And I can go on. There were much debauchery and illegal activity. Also, I also saw a lot of cops, but I didn't personally witness one arrest. Most cops, sorry about that, I hit the wrong button, folks. Most cops just look on as thousands of people flouted the law. In fact, many of the cops seem somewhat amused by the antics, trying to engage in any above activities in downtown Tampa on a normal Tuesday night, and you will quickly find yourself taking up residence at a Hillsborough County jail. Sure, people make some arrests and issue a few citations during Gasparilla. 11 arrests in 2019. Yes, you read that right. 11. I did not mention an estimated 300,000 people attended the event. Fact, hundreds of thousands of revelers crammed into downtown Tampa for Gasparilla, and huge numbers of those break one or more laws with impunity. Simply put, the relative small number of cops could never hope to control the masses and force compliance with the law. So they sat back and generally just tried to contain the mayhem. This illustrates as an important reality. As more and more people simply ignore a command, those trying to enforce it find it increasingly difficult to do so. It boils down to a simple matter of resources, manpower, and scale. A few hundred cops cannot enforce their will on 300,000 people. Herein lies the secret to our nullification strategy. States don't have to actually do anything. They just have to stop helping the feds enforce federal laws or implement federal programs. The laws may remain on the books, but they become impossible to enforce. For all practical purposes, noncompliance rendered them null, void, and of no effect. State and local noncompliance with federal acts, rules, regulations, and the implementation of federal programs creates the same dynamic for federal agencies as Mardi Gras or Gasparilla does for local law enforcement. When enough states refuse to comply or cooperate with the enforcement of a federal act, D.C. finds it increasingly difficult to impose its will. James Madison understood this dynamic. That's why his blueprint to stop federal overreach in Federalist 46 was a refusal to cooperate with enforcers of the Union. Madison said a single state refusing to cooperate would create impediments. And there were sentiments of several adjoining union states happened to be in a union would present obstructions which the federal government would hardly be willing to encounter. In fact, the federal government depends on state and local cooperation for virtually everything it does, enforcing drug laws to implement its many programs. During the run-up of the 2013 federal government shutdown, the National Governors Association sent a panic letter to congressional leadership begging them to avoid the shutdown. In this email, the governors affirmed the feds need the states. States are partners with the federal government in implementing most federal programs. A lack of certainty at the federal level from a shutdown therefore translates directly into uncertainty and instability at the state level. Do you catch that? Most federal programs. That means states can refuse to serve as a cooperative partner and shut down most federal programs. There is a great power in the word no. Cops can't control Gasparilla partiers, and the feds can't control states. State governments just need to stand up and assert their authority. They need to say no. This article was adapted from an excerpt from our last hope, rediscovering the last path to liberty. And he's absolutely correct. This is why, my friends, all you folks out there worry about these tougher gun laws, all that, every state in the union can give the Washington, D.C. the big middle finger. And what the Fed's going to do? Nothing. They can say whatever they want. Don't mean a thing. Always tell people, keep calm. We got the 10th Amendment. Doesn't matter who's in there, folks. Without us, the federal government is nothing. So anything that's considered an illegal contract, unconstitutional, the states can say, we're not going to support it. Have a nice day. And that will be it. I'd like to thank everyone for listening. Plus, feel free to download and share us throughout your social media networks. If you have any questions, comments, or something interesting you want to check out, whatever you do, please send your correspondence to Decorum. Furthermore, I'll leave the footnotes of these articles on my Spreaker page. And if you want to contact me by email, you can hit me at LookYouLuck03 at protonmail.com. And if you want to send some donations, you can hit me at paypal.me or cash.app/LookYouLuck3. And if you want to donate or support the Epoch Times and the 10th Amendment Center, that will be beautiful. And I thank you in advance. Once again, thank you for your time. But always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love. And may your guardian spirits be with you.